next presentation is on confidentiality and mandatory reporting. The presentation will provide an overview of Kentucky's mandatory reporting requirements for child abuse and vulnerable adult abuse, including a discussion on balancing the duty to report with maintaining client confidentiality. I'd like to present Eve Rabinoff. Okay. And there are a number of people can attest to that I butcher their names, so thank you. She is a training coordinator at the Kentucky Association of Sexual Assault Programs, and prior to joining KSASP, Eve was an advocate at a local sexual violence resource center and worked in higher education. Thank you.
Hi, everyone. Hello. Can everyone hear me okay? Yeah. Okay. So thank you for that introduction. Thank you for being here with me. I'm Eve Rabinoff, and I'm KSASP's training coordinator. And I prepared this presentation with our staff attorney, Jenna Cassidy. So I just wanted to give her a shout out here and credit where credit is due. So we're going to talk about confidentiality and mandatory reporting today. But before we do, I wanted to just do a brief overview of what KSASP is, who we are, what we do, and how hopefully you all can get involved in the movement to end sexual violence. So KSASP is the Kentucky Association of Sexual Assault Programs. That's what our acronym stands for. And who we are is the coalition of Kentucky's 13 sexual assault programs. You might also hear them called rape crisis centers. That's how they're referred to in the law and in the regulations, and sometimes we abbreviate that to RCCs. We like to call them sexual assault programs or sexual violence resource centers, just to indicate that we serve all survivors of sexual violence. It doesn't have to be rape in particular. So we are the coalition of Kentucky's sexual assault programs, and our mission is to speak with a unified voice against sexual victimization, and we serve as a central point of contact on sexual violence issues in Kentucky. So what does that mean? Really, what we work to do is to ensure that survivors have an advocate, both at the local individual level, at the level of the sexual assault programs, and also at the statewide level. So making sure that survivors have an advocate in legislative conversations and policy conversations. We do statewide prevention work to really work towards a world free from sexual violence. And we also work to ensure that the response to instances of sexual violence is consistent and high quality throughout the state. So more concretely, what do? We provide training and technical assistance, both to our member programs and to community partners. We also provide training in the form of a webinar series. Each month, we host a webinar, something educational about an issue related to sexual violence, and that is open to whoever is interested in those. And in just a moment here, I'll pass around an email sign-up sheet in case you want to get on that list. We also do public policy advocacy, and my colleague who put this presentation together with me, Jenna, she works year-round, both in session and when the legislators are out of session, to work on improving Kentucky's legislation to help survivors across the state. We also host a committee called the SART-AC, that's the Sexual Assault Response Team Advisory Committee. And this is a multidisciplinary committee that meets quarterly and really works to ensure, again, that the systems level response, the medical response, the legal response to sexual violence in Kentucky is working well. And that is also something that folks can get involved in. As I mentioned on the previous slide, we do statewide prevention programming, and one that we host regular trainings for is Green Dot. Has anyone heard of Green Dot? Yeah, great. So about annually, KSAP will host a Green Dot training, and that is open to community partners. We also do public awareness events, such as Sexual Assault Awareness and Prevention Month. That's SAPM up there. We have a kickoff every year at the end of March, and also that is open to the public. So if you're interested, this year we're going to be hosting it in Elizabethtown. And we also host a now biannual conference. So in everything that we do, we try and foster connections. We're a coalition, and we're trying to build connection both within people who are directly working to support survivors of sexual assault and other people who have an interest in this. So we try and be a point of connection. So get in touch with us. If any of this sounds interesting to you, you can get in touch with us. The QR code up there will take you to our website where you can find the email addresses for everybody who works at KSAP. You can get in touch with me if you're interested in bringing a training to your organization. You can get involved in these statewide initiatives. Also, you can get in touch with me and I can direct you to the person who's most relevant in those things. If you have an idea for legislation that would help support survivors, get in touch with Jenna. She can help get you involved in that advocacy work. You can join our training email list if you want to hear about our webinars. And you can also join our quarterly newsletter if you want to just keep up with what KSAP is up to quarterly. You can follow us on Facebook, attend one of our events. And I'm going to move away from the mic here just so I can pass around my email list sign-up sheet. If anybody in Zoom land wants to sign up, you can send me an email. My email is training@ksap.org. Okay, so that's KSAP, that's my organization, but we are, most of all, the coalition of the 13 sexual assault programs in the state of Kentucky. So this is a map, and I also have and for Zoomland folks, you can find all this information on our website. And so really, I just wanted to show this to you all so you could see that every single region in Kentucky is served by a sexual assault program. So no matter where you are, where you live in Kentucky, there's somebody there to help you if you are impacted by sexual violence. And you can find yours and connect with them. And so what do our sexual assault programs do? They all, each and every one of them provides confidential, which we'll return to in a moment when we get into the meat of the presentation today, but confidential and free services to anybody impacted by sexual violence. So that includes people who have experienced sexual violence themselves, but it also includes family and friends who are indirectly impacted by sexual violence. They're helping to support their loved one, their friend. And it also includes professionals. So if you encounter survivors in the course of your professional work and you want some advice about supporting survivors, or if it's just taking an emotional toll on you and you want some emotional support around that, you can call your local sexual assault program as well and get support there. All of the sexual assault programs provide these services that are listed on the slide here: a 24/7 crisis support line, 24/7 medical advocacy, which means anytime a survivor shows up at an ER for a forensic exam, an advocate is dispatched from one of our sexual assault programs. 24/7 legal advocacy, so our advocates will accompany survivors to hearings, to meetings, and really just help them to navigate whatever legal system they're facing. That could be a criminal case, that could be in the civil system, so they will accompany survivors when they're seeking protection orders, for instance. But really, whatever the legal system is, our advocates can support survivors through that. We provide crisis counseling, we provide free trauma-informed therapy. I should say trauma therapy. It's more than just trauma-informed, although it is that too. Prevention education, outreach and awareness. So April is Sexual Assault Awareness and Prevention Month, and your local sexual assault program will host a variety of different events that you can get involved in. And they do other kinds of outreach and awareness. They provide trainings to community partners in their communities, and consultations and also referrals. So there's lots of possibility for engagement with folks who are interested in violence prevention and response. Okay, so we're going to move into mandatory reports, but does anybody have any questions before we do that about KSAP or our sexual assault programs? Yeah. Mm-hmm. Mm-hmm. I think there are lots of different examples of that. So one thing that I should maybe say, first we let the survivor define their experience. So we don't say what happened to you does or doesn't count as sexual violence. So that's answer number one. But I think also more generally, sexual violence doesn't have to be physical contact. So sexual violence includes things like stalking, for instance. That can be a version of sexual violence, and stalking is written into a lot of the sexual crimes in the statutes. Harassment at work can be sexual violence. Let's see, and you know, with the AI stuff, there's just all this new kind of exploitation and violence when people use somebody's image in a sexually exploitive video or picture or something that counts as sexual violence. So really it's a big bucket. And we don't take it upon ourselves to try and say like this counts or this doesn't count. If you feel violated, you can come to us and you will receive services. Okay, so mandatory reports. I just want to start with the basics. I imagine that most of us here are already familiar with this, but just so that we are starting from the same point. All adults in Kentucky are mandatory reporters, without exception. We're all required to make these reports of child abuse and vulnerable adult abuse. So what does it mean to be a mandatory reporter? It means that you, by law, must make a report if you have reasonable cause to believe that a child is being neglected or abused. And if you have reasonable cause to believe that, you have a choice whether you want to report it to the Cabinet for Health and Family Services, DCBS, Department of Community-Based Services, or you can report it to law enforcement. You also must make a report if you have reason to believe that a vulnerable adult is being abused or neglected. And a vulnerable adult is defined in statute as someone who, due to a physical or cognitive disability, cannot independently take care of their basic needs. And if you have reasonable cause to believe that this is happening, you have to report it to the Cabinet for Health and Family Services, Department of Community-Based Services. And I want to point out here also, like I think sometimes we think that this aspect of the mandatory reporting law only applies to elderly folks, and that's not true. It's anybody over 18 who, due to some physical or cognitive disability, cannot independently take care of their own basic needs. So that could include elderly folks, not all elderly folks, and it also includes people throughout that lifespan of the adult. Knowing that a report has already been made doesn't relieve you of your duty to report. So if you are, for example, sitting in a room with your coworker and both of you at the same time discover that a child is being neglected, you would both have to make that report. You could do it together, but you would both need to be involved in that report. I think it's important to realize that there's no general duty to report crimes of sexual violence. Just as there's no general duty to report any crimes, that's true of crimes of sexual violence as well. And also that there's no duty to report domestic violence. And that's a relatively recent change in the law. I think it was 2017 or so that it was changed. So we want to just make sure that everybody is aware that there's no duty to report domestic violence, though there is, for some professionals, a requirement to provide resources and education to survivors of domestic violence. And if you want to learn more about that, you can go to zeroV.org. Zero V is the Coalition of Domestic Violence Program, formerly known as KSASP. And I didn't put links in these slides, but I can follow up with an email with all these links if necessary. Okay, anything surprising on this slide? We all on the same page? Okay. So what's the big deal? Why do we have to spend all of this time talking about mandatory reporting? Why can't I just make a report whenever I think a child or a vulnerable adult is being harmed? And the answer to that is confidentiality. So the duty to report, these mandatory reports, are an exception to confidentiality requirements. In our case, and I'll talk about this more in detail on the next slide, in the case of sexual assault programs, confidentiality is also required by law. So we have to balance the legal requirement to maintain client confidentiality with the legal requirement to make these reports, which violates confidentiality. You're giving somebody's information to somebody else. You're not keeping it private. So who here is also subject to some kind of confidentiality requirement? HIPAA or anything else? Yeah, a few people? Okay. So for all of us, we really have to understand when we have to make a mandatory report, because we're required to make that report, and we can't make it if it's not a mandatory report, because our confidentiality requirements would kind of override the impulse to make a report to the authorities about abuse or neglect. So professionals must make a report when and only when a mandatory report is required. If you're not bound by confidentiality requirements, if you're not acting in your professional capacity, you can just make a report when you think that's appropriate. So if you see a neighborhood kid with some bruises, you might make a report. If you're encountering that kid in your professional capacity, you have to be sure that that's a mandatory reporting situation if you're going to make that report. So that's why this is a big deal. So let's talk about confidentiality for a little bit. And different professionals have different confidentiality requirements that they're subject to, and I can only really speak to our own. Let me make sure. I've totally lost track of my notes here, so let me get to the right page. Here we go. Okay, so for our sexual assault programs, everything that the client shares is confidential, which means cannot be shared with anybody else unless it's a mandatory report or unless you get a release of information. So this applies to the records that our agencies keep, and it also applies to any other kinds of communications that we receive from the client, from the survivor. And it also applies to the whole agency. So the confidentiality requirements, it's not just for therapists, it's not just for advocates even, it's for everybody who works in a sexual assault program in a rape crisis center. So that includes the prevention educators, that includes the administrative staff. Everybody is bound by law to maintain the confidentiality of client records and client communications. We do use releases of information, which is when the client tells you, yes, it's okay, and I want you to share this information. But we do it in a way that is very specific and time limited. So we might get a release of information that would permit an advocate, say, to talk to this law enforcement officer about this specific part of their case, and this release of information is in effect for 3 months. So they're very time limited and very specific. which can be frustrating, I know, when you're collaborating with other professionals. So I wanted to just talk for a brief moment about why we do this. We really hold confidentiality to be kind of sacred. And it's because not only is that the law, but it's because practices of confidentiality are ways of empowering survivors. Everything that we do in our work is rooted in this idea of empowering survivors. Why? Because sexual violence is an act that disregards a person's autonomy, agency, and dignity, and may also lead to feelings of shame or guilt. And so empowering, which means restoring choice and restoring control to somebody who has experienced this, is both a trauma-informed practice and is a healing practice. So everything that we do, we try and do in a way that empowers survivors, and confidentiality is one of those things. It ensures that survivors maintain control and choice about how their information is shared, whether it's shared and whether it's used, to the degree possible, at least when it comes to us. And it also means that survivors have a safe space where they can talk about what happened to them without worrying about who else is going to know. So that's the why for confidentiality. And so if you ever, come against a barrier and an advocate has some information that you want and they're not sharing it with you, remember that why. They're not doing it to be annoying. They're not doing it to put a roadblock in your way or make your work harder. It's because they're doing it to make sure that survivors are empowered, make sure that they have as much control over their information and their story as possible. So confidentiality in practice, what this looks like is, if you're a medical professional and you encounter an advocate in the hospital, those advocates may be speaking privately with survivors and they won't be able to talk with you about their conversation with the survivor. In legal contexts, same thing. The advocates might have information that you want that might help you with your case. They won't be able to share it without a court order or a release of information. And they're also going to ask you for information because part of their role is to make sure that the survivors are informed about the process of their case. Does anybody here sit on a multidisciplinary team, which is hosted by the CAC to oversee and make sure that children who experience violence are cared for? Anyone? No? Okay. Well, in these kinds of meetings, you might see advocates from the sexual assault programs. They might be working with the client under discussion and they will not be able to say anything about that client, again, without a release of information. They're there in a more general role just to provide information and advice about working with survivors generally. Same with schools. Our prevention educators do programming in schools like Green Dot in high schools. And sometimes students will talk to them about their experiences of violence, and they won't be able to share that with other school personnel for the same reason. And just in general, this is how deep our confidentiality commitments go. If you were to call up your local sexual assault program and say, I just need to know if this person is receiving services from you, and maybe you need to know that because they have a crime victims compensation claim or something like that, the sexual assault program isn't going to say anything about it because they're not going to reveal whether somebody is their client, because that is indirectly revealing that they have been impacted by sexual violence, and that is already too much. Okay, so I know this can feel like there's a lot of barriers. Maintaining confidentiality means that we're not going to be sharing information readily with other professionals that we collaborate with, but there still is a lot of room for collaboration, and we value collaboration. Responding to sexual violence and ending sexual violence is an all hands on deck kind of endeavor. So room for collaboration, consultations and referrals. For sure, if you need to talk to somebody about supporting a survivor, you can call your local rape crisis center and they can talk you through that. You can make referrals to them. They can make referrals to you. And of course, we all know if you have a relationship between your agencies, those referrals are often much more successful. You can collaborate on sexual assault response teams. So I mentioned the SART-AC, which is the statewide sexual assault response advisory committee, but there are also local sexual assault response teams which really work to make sure that the systems level response to survivors is working well. So you can get involved with that. Of course, if a client provides a release of information, you can collaborate on supporting that specific person. And you can also provide cross trainings between your agencies. So there are lots of room for collaboration. I'm sure this is not an exhaustive list, but I do want to just, while I'm saying we can't share a lot of information with you, I also want to say we want to be partners with you. Okay. So that was confidentiality. Do we have any questions or comments about that before we move on? Am I talking too fast? Okay, good. Just checking. All right, so we're going to start talking about mandatory reports, and we're going to start with a focus on child abuse and neglect. And I want to start with what is, I think, a common misunderstanding about mandatory reports, which is that any violence against children is a mandatory report. Seems common sense. But the reality is that only child abuse is a mandatory report, and child abuse is not synonymous with violence against children, which means there are certain kinds of violence against children that would not trigger a mandatory report, and you would be violating your confidentiality requirements if you did report it. And the key thing that makes the difference is the relationship the child has to the person who harmed them. Excuse me, Wally. Okay. So first, what counts as child abuse? What kinds of behaviors count as child abuse? Any physical or sexual harm, maltreatment, or neglect. There are a couple of others that we'll get to in the next slide. And this is the kicker. When done by a parent, a guardian, a person in a position of authority or special trust, or a person in a position of custodial control or supervision. So those are the categories of people. If they cause harm, that would be a mandatory report. And also that third bullet point here, it's not only when such a person causes the harm themselves, but also whenever they create a risk of or allows the harm to be committed. So just some examples there on the other side of the slide. Physical harm could be something like pushing a child down the stairs when done by a guardian or a babysitter or a teacher or, I don't know, a religious authority, a camp counselor, anything like that. Sexual harm, so that includes any kind of physical, sexual contact. It also includes things that doesn't involve sexual physical contact, such as masturbating in their presence or forcing children to engage in sex acts with each other. I'm sorry, most people aren't used to talking about these things aloud all the time like I am, so I'm sorry if some of these things are uncomfortable to say or hear. Maltreatment might include driving drunk with a child. Neglect might include leaving a child home alone overnight, a child being undernourished, or in general, a person in a position of caring for that child, depriving them of their basic needs. And then this creating a risk of or allowing is like, for example, if a parent knows that their child has been abused by the neighbor down the street and still leaves the child with that neighbor in a caretaking role, that would be a mandatory report because that is allowing or creating a risk of further harm. Yeah.
So when you say parent guardian, is this all about the 18 years or older? Is that the parent or like a babysitter is 16, 17?
Yeah. No, that does. Yeah. So we got a whole big slide on this, but yeah, so age here matters less than relationship. So position of authority is defined in the law as included but not limited to parents, youth leaders, so those youth leaders might be, 17 years old or less, coaches, teachers, school employees, counselors, staff, volunteers for residential treatment facility, staff or volunteer with youth services organizations, religious leaders, healthcare providers, or employers. And a position of special trust means a person in any of those kinds of relationships who also exercises undue influence over the minor. But I think like the real bucket categories are people exercising custodial control or supervision. So that is not somebody who's in like a kind of professional role with a relationship of authority to the child, like for instance, a teacher would be, but it could just be a babysitter or an older teenager who the child really looks up to, so somebody who has that kind of influence over the child, somebody who is just looking out for the kids in a role of supervision. So the details always matter, especially when there isn't this kind of official relationship like a teacher or a parent or something like that. There still might be a relationship of authority or influence or supervision or custody that would be important to look at when you're considering this. Yeah. Yeah.
Sexual abuse relationship.
Yeah.
Peer-to-peer, age same, not, these cases not going to accept that unless there's a supervisor prohibited.
Yeah.
Unless the person with authority, like
Yeah.
stable,
Yeah.
safe,
Yeah. Yeah, absolutely. And that goes back to that idea that not all violence against children is a mandatory report. It's only child abuse. And it also goes back to that idea that not all crimes of sexual violence are mandatory reports. And I think that sort of like peer-to-peer sexual violence is a good example of that. Unless, and this was my last example on this slide here, unless there's a lack of caretaking capacity on the part of the guardian. So if a teenager is assaulted by her boyfriend and her parent still continues to let that boyfriend spend the night, that might be a mandatory report, not because of the crime of sexual violence, but because of the lack of protective capacity that's creating a risk of or allowing. Are you from DCBS? Okay, so please jump in if I miss anything or to correct anything. Yeah. Yeah.
So if a non-caretaking older kid offends another kid, playground or whatever,
Mm-hmm.
and is not a caretaker, and it's a sexual assault,
Mm-hmm.
I know that DCBS gets that, they will give it to law enforcement because it's not a caretaker, it's still a crime.
Mm-hmm.
Does the person not have a duty to report that anyways?
Yeah, if you're bound by confidentiality laws, you actually can't report it. So if the child told you that this happened, and you're the advocate for the child, they tell you privately, and it's not a mandatory report because it's peer on peer, you can't report it. You have to maintain that child's confidentiality. You could do other things, and I have a slide about that, but yeah. Yes, absolutely. Yes. Yeah. Mhm. Mhm. Yeah. 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 I would say yes. And like the thing about doing these presentations is ultimately, these are going to be a matter of judgment, and the details really matter. So the details of the domestic violence and the child's closeness to it, I think, would matter in those circumstances. But I would say, yeah, especially if it's physical abuse in the child's presence, the child could easily get wrapped up in that and experience harm themselves. Yeah. Yes, I would say so. Though I would keep in mind the idea of empowerment. So if somebody really doesn't want you to make that report, and it's not a mandatory report, I would err on respecting that person's wishes because they know best about how to keep themselves safe. Yeah. Mm-hmm. Mm-hmm. Yeah. I know. I know. Yep. Yep. And so maybe I'll skip ahead to this. I've got a bunch of scenarios for us to try out, but I'll go back to these. Okay. So I think we kind of, mandatory reports are so important that they kind of overshadow the other kinds of supports that we can provide when you're bound by confidentiality not to make a mandatory report. So not making a mandatory report doesn't mean not doing anything to support that person. So you can safety plan with young children. That's trickier, but you can at least help them, identify who safe people are. You can encourage the child to discuss this with a counselor or somebody who isn't bound by confidentiality. You can, that's maybe a little bit weaselly, but you can encourage the person to discuss this with other people. And you can even offer to accompany them in discussing this with other people. You can always ask them if they would like to make a report, and you can support them through that process. And you can always, if you're not comfortable doing these things yourself, you can always refer them to the local sexual assault program or the local domestic violence program or the local child advocacy center, or whatever is appropriate to help them through this themselves. You can refer them to the crisis text line, where you text Kentucky to 741-741, or the 988 crisis line. Yeah, so there are lots of different things that you can do to help keep them safe that isn't a mandatory report. Yeah. Mm-hmm. Yeah. 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 Mm-hmm. Mm-hmm. Yeah. 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 Yeah, and I think again, that would be a matter of judgment, whether it qualifies as a mandatory report, given the risk of being in a kind of violent situation. It might be, but I think the details really matter there about whether it's a mandatory report or not. And again, if it's your neighbor and you're not operating in a professional capacity, you can make that report just because you think that's going to help keep that child safe. But if it's in a professional capacity and you're bound by confidentiality, you might have to get a little bit more creative about how to keep that child safe. Yeah.
I'll turn that to one.
Yeah, that's fine.
I think there's a correlation between TV and child supply.
Mm-hmm.
One of the things was reported on TV for the child from the DCPS perspective, the policy they will ask you to do is not witness. When before or in addition
Mm-hmm.
to making that report published.
Yeah. Yeah. Yeah, absolutely. The connection with a supportive adult is one of the strongest protective factors, right? Yeah, so you could be a supportive adult in a child's life, and that could be an even more lasting thing that you can do to keep that child safe than making the report, which may or may not get accepted, which may or may not, there are a lot of ifs when the report gets made. We also have to recognize that trafficking and female genital mutilation of a child are also mandatory reports. And these are mandatory reports independent of relationship to the person who did this harm to the children. So in a way, these are simpler. If you have reasonable cause to believe that a child has suffered female genital mutilation, which is any procedure harmful to the female genitalia, or if you believe that a child has been trafficked, and that includes forced labor and also commercial sexual activity, those things you have to report. Often when you hear about trafficking, people emphasize that it's only trafficking if force, fraud, or coercion is involved. For the purposes of mandatory reporting, and this is happening to a child, you don't have to worry about those things. So if you think a child is being forced into labor or being, I just said forced, right? If a child is doing forced labor or is engaging in commercial sexual activity, report that. Summary so far. Child abuse or neglect is harm against a child, which is physical or sexual, or neglect of the child, caused by or allowed by a person in position of authority, influence, or supervision, and also labor or sex trafficking of a minor, regardless of who caused it, female genital mutilation of a minor, regardless of who caused it. And whenever you have a reasonable cause to believe that this is happening, you must report it. And that reasonable cause to believe, I think, is really where the judgment comes in. And also it's important to realize that you don't have to prove this in court. You don't have to be able to prove this in court before making a mandatory report. It's really like, if you have good reason to believe that this child is suffering abuse or neglect, that's when you make the report. And then DCBS will take over and they'll do their investigation and decide, whether or how to move forward to keep that child safe. So we got some scenarios to test it out. Okay, you witness a 10-year-old kicking and hitting an 8-year-old on the playground. Is this a mandatory report? Show of hands who says yes. Show of hands who says no. Awesome, right. Because there isn't that relationship of authority there. You might find out other details later, like maybe the difference in cognitive ability or something like that, that might make it a mandatory report, but if this is all you know, you don't report it. You witness a teacher hitting and kicking a 15-year-old on the playground. Who says that it is a mandatory report? Yeah, any no's? All right, awesome. And that's because of that relationship of authority. 13-year-old Manny tells you that his coach asked him to pose naked for photos. Who says that this is a mandatory report? Any no's? You got it. It's that coaching position. This counts as sexual violence or sexual abuse. That would be a mandatory report. 17-year-old Sally tells you that she was assaulted by a stranger in a park. Is this a mandatory report? Who says yes? Who says no? We got some no's. And some people who are maybe unsure. Yeah. So this wouldn't be a mandatory report if this is all you know about it. And that's because she was assaulted by a stranger. So it's harm, but it's not child abuse. So it wouldn't be a mandatory report unless there are some other factors involved that would make it, lack of protective capacity, or maybe you find out that it wasn't really a stranger, something like that. And so that leads us to some more complications when we're talking about child sexual abuse. And this is another thing that I think we commonly think that's actually a bit inaccurate, which is that any sexual violence against a child must be reported. That's what we want to do, I think, for sure. But the reality is that relationship matters, like we've just discussed, and also the age matters, but probably not in the way you think. So who here has heard that 16 is the age of consent? Yeah. It's something that we probably say commonly, age of consent. This is a common phrase in our vocabulary. This is something that my coworker Jenna is very insistent about, which is that we shouldn't be doing that because age of consent is a legal concept and it applies only in narrow circumstances. And part of the problem with kind of figuring that 16 is the age of consent is that it would imply that any sexual intercourse with people under 16 is illegal, which isn't true. 15-year-olds can be sexually active and that's not a crime, right? So remove age of consent from your vocabulary. That's Jenna's advice and I am her mouthpiece here. I think it's good advice. But where does it come from? Why are we focused on the age of 16? It's because of this feature of the mandatory reporting law. We have a duty to report the child abuse of a minor who is under 16, who is a victim of sexual abuse, sexual exploitation, or prostitution by any person older than 21. So this is another case where relationship doesn't matter. If the child is under 16 and the person who's causing the harm is older than 21 and it's sexual harm, that's a mandatory report. So I think that's where like the idea of 16 really comes in. So what does this mean? I just said this, if it's sexual violence of a victim under 16 and the perpetrator is 21 or older, make that report. You don't have to know anything about the relationship. But, and this is just an example, if it's a case of sexual violence, the victim is 15 years old and the perpetrator's 18, so less than 21 years old, barring other factors, that's not a mandatory report. So, take Sally again, assaulted by a stranger in a park. What would have to change about this scenario to make it a mandatory report? Yep, think about that. If it was her boyfriend and he was 23, but she has to be younger than, yeah. So her age, yeah, and the boyfriend's age, yeah. Yeah. If it was a coach or a teacher or someone in a relationship of authority, absolutely, yep. So we could change the ages and then we wouldn't need to know if it's coach or not. If we don't change the ages, if it's coach, you make the report. Okay, 12-year-old John tells you that he was raped by a 20-year-old stranger. Mandatory report, yes? No? Unsure? This is a hard one because the answer, barring any other information, it's no. I know, this is like the mind-blowing part. But he's younger than 16, but the perpetrator's only 20. So he's younger than 21, he's younger than that age cutoff, and he's a stranger, so there's no relationship of authority. Yeah.
If you were not had a professional relationship with this person, reporting is no harm, no foul.
Yes, exactly. If you're not bound by confidentiality, you can report. So this may or may not apply to you, but if you are bound by confidentiality, if you're John's, mental health counselor and he tells you this, you can't make that report unless he wants you to, So that's hard. Some other scenarios, just because I think the age thing can get kind of tricky. An 11-year-old tells you that her 12-year-old boyfriend sexually assaulted her. Is this a mandatory report? Who says yes? Who says no? That's right, it's not a mandatory report. Barring other circumstances, always, the details always matter, but if this is it, they're a peer-to-peer relationship, and the age gap is not such that it would be a mandatory report. Yeah. Then it does become a mandatory report because there's a risk. Exactly, exactly. A 17-year-old was sexually assaulted by his 21-year-old teammate. Who says this is a mandatory report? And who says no? No. That's right. This, again, wouldn't be a mandatory report barring other factors. They're a teammate relationship, so it's peer-to-peer. And this person is 17, so he's older than that 16-year-old cutoff. So even though the perpetrator is 21, he's not below 16.
So, but using the term assault, you're saying this is a way, this is a non-consensual because it's sexual assault.
Right, yeah. It could be rape, it could be some other kind of sexual violence. So it doesn't have to be sexual, it doesn't have to be rape. Yeah, or any other kind. Yeah, sexual harm, I think, is the term we should be thinking of. A 15-year-old sneaks into a bar and is sexually assaulted by an older man who is a stranger. She doesn't know his age. Would this be a mandatory report? Yes? No? Need more information? Need more information. I would think because it's a bar where presumably people are 21, or they should be, you have reasonable cause to believe that this person was 21.
But that becomes the fact of the parents. They were not necessarily about.
Yeah, I think the details would matter there. Yeah, because I would be reluctant to hold a parent accountable for a teenager who does something they shouldn't, just if it's like a one-off or whatever. But yeah, you would probably want to consider that. Yeah.
So if you're bound by confidentiality, you find out later that this person is a 17-year-old also something.
Yeah.
What are the consequences of breaking that confidentiality? When you're not supposed to. It's apology.
Yeah. Yeah, I think that you're protected by that reasonable cause to believe thing. So as long as you made the report in good faith, if you broke confidentiality and it turns out that the facts didn't support that, that's still okay. I mean, you were doing your best with the information that you had at the time. So maybe, I don't know, maybe your supervisor would say, you need to brush up on your mandatory reporting, requirements, but there wouldn't be any like legal repercussions or anything like that. Yeah. Yeah. Mm-hmm. Yeah. Yeah. So I think I think like the answer is kind of the same. Like you didn't know at the time that he was 25, so you didn't make the report. Now you know, and so you have to make the report now. Yeah. So it's not like the mandatory reporting requirement is like just given the one set of circumstances. Mm-hmm. I think that, so the advice that I've heard Jenna give, who's the lawyer, is that unless like these set of facts has already been adjudicated and decided by the courts, make the report. So if the process is ongoing, just make the report. Just kind of, yeah, just to be sure that you fulfill your requirement. Yes. Absolutely. Yes, you could call Jenna and she would walk you through it for sure. Yeah.
So is there any way you can notify my 12-year-old child is telling me one of these things? You won't tell me. You have sense.
I know. Yeah.
Because I mean, how can I protect my child?
Yeah.
How can I make sure my child is not that person again?
Yeah.
How can I-
If that child is seeing a sexual assault program advocate, they can't share the information. Even with the parent, they can encourage the child to talk to the parent or set up like a session, like a therapy session in which the child can talk to the parent about it, different kinds of things like that. But no, there's no, at least for our professionals, there's no requirement to inform parents. Right, or like maybe a teacher, there might be school policies around that. So for different organizations, I think the answer to that's going to differ. Yeah. 18-year-old who is raped by her 22-year-old boss. Mandatory report, yes? No. She's 18, she's an adult, so she's not a child. I know that was a trick one. But that's also important to keep in mind because, you know, maybe she's a senior in high school, and so you think of her as a child, but if she's 18, it's her choice to report what happened to her or not. Yeah, and so we already saw this slide. Just, I think, again, it's really important to remember that reporting is just one thing you can do to help keep kids safe, and there are lots of other things that can be done. I think I'm going to skip this for the sake of time. Yeah. Yes. Yes.
I think it just reiterates the significance and the importance of the supports
Mm-hmm.
the child moving into this and our report and our non-report, because it really concerns me about there and
Yeah. 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 I think that's a really important point. And I will also use it to segue into a plug for our school programs, our violence prevention programs. So Green Dot, and there's also a middle school program that we do called It's My Space, which the It's My Space program teaches kids about healthy boundaries and healthy relationships, so that if their boundaries are violated by another kid, they feel like they have the tools to recognize that and do something about that. And the Green Dot program teaches kids to intervene in instances when violence might happen. So, and also tries to change social norms so that violence is less accepted and intervening to keep other kids safe is more accepted. And so I think like these can also be really important tools for these kids who are experiencing violence at the hands of other kids. Like their peers can help keep them safe too. So neglect. We can't forget about it. This is also within the mandatory reporting requirements. And so this is what is said. This is not everything that's said in the Kentucky Revised Statutes, but this is what I wanted to pull out. It's whenever a parent, guardian, or custodian engages in a pattern of conduct that renders that parent incapable of caring for the immediate and ongoing needs of the child, or when such a person continuously or repeatedly fails or refuses to provide essential parental care and protection, if a parent or guardian or custodian abandons the child, or if such a person does not, provide the child with adequate care, supervision, food, clothing, shelter, and educational or medical care necessary when they're financially able to do so. There is, in the definition of neglect, a religious exception for that lack of provision of medical care. I think for the purposes of mandatory reporting, you don't need to know whether that applies. I think most of us probably wouldn't be in the position to judge whether that applies, but just do note that there is that exception there. So, which of these is a mandatory report? 11-year-old Fred tells you that his only meals are school meals and there's no water or electricity at home. Mandatory report? Yes. 12-year-old Angelica tells you that her 5-year-old cousin was left alone in her house for 3 days in the cousin's house. Mandatory report? Yep. 16-year-old Samara tells you that the reason she's failing her classes is that she always has to look after her 3 younger siblings, has no time to get her homework done, and so she's too tired to focus in class. Mandatory report? I wrote it thinking that it was. There's always room for discussion about these things, but I would say that that's some kind of neglect. She can't do her schoolwork. It might be educational neglect. 14-year-old Sasha has a rotten tooth, and he tells you that his parents won't make a dentist appointment for him. Neglect? Yeah. Medical care, what do you?
It's not going to be accepted unless you make a connection between the child and the pain. What is the, what has to have a consequence to it? And it brought to this kind of day.
Okay, that's good to know.
And it applies to all of these things.
Yeah. 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 Mm-hmm. Right. Yes. Yes. Yeah, I think that's a really good point. Yeah, like it might not be a problem that Fred's only meals are school meals if he's getting 3 meals a day at school. Yeah, or so things like that. Details always matter here. Vulnerable adult abuse, we'll be quick here. Again, a vulnerable adult is a person who's 18 or older who, because of mental or physical dysfunctions, are unable to manage resources, carry out daily living activity, or protect themselves from harm. That's directly from the revised statutes. And you have to make a report when you have reasonable cause to believe that a vulnerable adult suffers physical abuse, sexual abuse, neglect, or exploitation. In these cases, you have to make the report to the Cabinet for Health and Family Services, the Adult Protective Services Wing. They will do the intake. They may or may not decide that to do the investigation, and then they will offer protective services if they deem that appropriate. But the adult has the choice to accept or not accept those services. So in this case, what does abuse mean? Abuse means the infliction of injury, sexual abuse, unreasonable confinement, intimidation, or punishment that results in physical pain or injury, including mental injury. Exploitation means obtaining or using another person's resources, including but not limited to funds, assets, or property by deception, intimidation, or similar means, with the intent to deprive the person of those resources. And neglect is a situation in which an adult is unable to perform or obtain for himself or herself the goods or services that are necessary to maintain his or her health or welfare, or the deprivation of services by a caretaker that are necessary to maintain the health and welfare of the adult. And that language also, I just copied and pasted from the statute. So there's a lot there. I think it's got a little bit of a different flavor than child abuse and neglect, so I wanted to give you the direct language here. And I think also, like, if you have questions about whether a person qualifies as a vulnerable adult or whether this course of action qualifies as abuse, exploitation, or neglect, you can also call the cabinet and ask those questions generally without making a report. They can kind of walk you through what all of this means as well. Okay, how to make a report. If it's child abuse or neglect, see, I forgot neglect. I just put child abuse on the slide. Can't forget neglect. Okay. You can report either to DCBS or to law enforcement. If you choose to report to law enforcement, you can do so at your local law enforcement, your local police station. You can report to the KSP, Kentucky State Police, or you can report to the Commonwealth's or county attorney's office. If you choose to report to DCBS, you can do so by calling their hotline, or you can make an online report. And I didn't put the link in the slides, but I will follow up with that as well. The online platform is monitored only from 8 a.m. to 4:30 p.m. So the advice that we've gotten is that if you're making a report outside of those hours, it's best to call the hotline. Do make sure that you have the time to spend, because sometimes there is a wait on the line. You have the choice to report anonymously, so you don't have to say who you are when you make the report. Always, always, always remember, if it's an emergency situation, call the police, call 911. What to report, and I think my summary here could be augmented, but what to report, if you have any of this information, you should report it. You might not have all this information, so just report the information that you have. But you would include the child and the caretaker's name and where they are. If there are any concerns about the child's immediate safety, the person's believed to be responsible for the abuse or neglect, so that may or may not be the caretaker, maybe it's the babysitter, and their relationship to the child, the nature, extent, and occurrence of the abuse or neglect, and if you choose to give them your own information, you can give them your name, address, phone number, email address. And if you do that, they may follow up with more questions. Also, when you make a report, you get like an identifying number for the report that you've made, so you can find out later if the report has been accepted for investigation or not. For vulnerable adult abuse, you can only report that to the Adult Protective Services branch of DCBS, but the reporting mechanism is the same, so it's the same hotline number or the same online form. For that report, you would include details about why the adult is considered a vulnerable adult and what you know about the abuse, neglect, or exploitation. But empowerment. So this is one of our core values. I think it's really, I think it should be adopted more widely. So I'm going to be an evangelist for empowerment for a moment here. So mandatory reporting is a situation where something is happening that the survivor or the client may or may not want to happen. So it's not in that structure a very empowering thing for the person necessarily. They might find it empowering, they might not, but it is something that they don't have a choice about. So that doesn't mean that the entire experience is disempowering. So there are lots of things that you can do as a mandatory reporter to empower the survivor within the mandatory report. And it's really based on this first bullet point here, the principles of transparency, inclusion, and choice. So if you have to make a mandatory report, I would say, please tell the person whose abuse you're reporting that you're doing that. Just let them know that this is happening so they're not surprised when somebody knocks on their door or calls them and says, we're doing this investigation. Let them know that you need to report it, and just explain whatever you can about it, of course in an age-appropriate way. But explain what a mandatory report is, who is going to be informed of the abuse and why you have to do it. And the why is to help keep you safe. I think that's true universally. That's why we're making these mandatory reports, to help keep people safe. And you can offer as much choice as possible in making these reports. You can say, we can do this together, or we can do it, or I can do it alone. Would you like me to make a report in writing in this online form, or we can call together. You can help me write this thing online, whatever they like, give these kinds of choices. If they want supportive people around while this report is being made, if they don't want to be in the room, but they really want to have some friends with them when they know this is happening, you can help arrange that. You can safety plan with the person. And of course, you can refer them to these local agencies who can provide support no matter what. So I do think that empowerment is important. I know it's not always possible, but in those cases where it is possible, I would encourage you to do this, because the violence, again, is already a disempowering experience. It's already somebody who's taking control of somebody else, not respecting their agency. So if you can support a person in regaining a sense of their own agency, that's going to be healing, and it's trauma-informed. Okay, and that's my soapbox. So this is the summary. We have done it. I think this is the last slide. So mandatory reports are an exception to confidentiality requirements, and they're not an optional exception. Even if you're bound by confidentiality of the strictest kind, like our sexual assault programs are, you have to break that confidentiality if it's a mandatory report situation. You also need to make a mandatory report if confidentiality doesn't apply. So that's the idea that all adults in Kentucky are mandatory reporters. If you have reason to believe that your neighbor is being abused, you have to make that report. You also have to make a report even if you happen to know that your coworker already reported this. That doesn't relieve you of your individual duty. You must make the report when you have reasonable cause to believe a child or a vulnerable adult is being abused. In the case of a child, the relationship matters and the age matters, especially in cases of sexual violence. In the case where it's not a mandatory report and you have to maintain confidentiality, you can still help. And if a survivor wants to make a report, that's great, they can do that. And you can support them in doing that. And try and be as empowering as possible by being transparent and offering choice and control wherever possible. And that's the end of my presentation. So thank you so much. I know that was a long presentation to sit through. You all have been a great audience. Please do reach out to us if you want to connect on any other trainings or the SARD AC or any other thing, or if you have questions about mandatory reporting, I can connect you with Jenna. You can contact me for anything you need from KSASP, and I will get your message to the right person. That's it for me. Thank you all so much.